The Supreme Court chamber fell completely silent. You could hear the faint rustle of robes and papers, the quiet hum of tension that always filled the air before something historic happened. Chief Justice John Roberts, known for his composure and strict control of proceedings, slowly removed his reading glasses and leaned forward in his chair. His eyes fixed on the woman standing at the podium, Congresswoman Jasmine Crockett. What had begun as a routine hearing on voting rights was about to become a moment that legal scholars would study for decades. "Congresswoman Crockett," Roberts said, his voice calm but resonant, cutting through the still air like a bell. "I must say, I've rarely encountered such clarity of thought under such intense questioning." For a brief instant, time seemed to pause. Members of the gallery exchanged stunned glances. Reporters looked up from their notes, unsure if they had heard correctly. Chief Justice Roberts, the stoic guardian of courtroom decorum, had just offered a public compliment, a rare, almost unheard-of gesture from the bench of America's highest court. And then came the moment that no one in that chamber would forget. Roberts nodded, a simple but profound gesture of respect. In that instant, a first-term congresswoman from Texas had earned something that few ever receive. In that marble room, the unmistakable respect of the nation's top jurist. If you want to understand exactly what Congresswoman Crockett said that earned such unprecedented recognition from Chief Justice Roberts, and why that exchange would echo through the legal community for years, stay tuned. Hit that like button, subscribe, and let's unravel one of the most extraordinary moments in modern constitutional history. To appreciate the gravity of what happened that day, you first need to understand the two people at the center of it all, and the high-stakes case that brought them face to face. John Glover Roberts, Jr., born in Buffalo, New York in 1955, had built one of the most impeccable legal careers in American history. Harvard Law graduate, clerk to then-Justice William Rehnquist, advocate in 39 Supreme Court cases before ever donning the robe himself. Appointed Chief Justice in 2005, Roberts became known for his measured approach, cautious, deliberate, and deeply protective of the court's institutional legitimacy. He disliked theatrics, avoided emotional displays, and prized clarity and control above all else. Roberts views himself as the guardian of the court's reputation, explained constitutional scholar Lawrence Tribe. He's extraordinarily careful about maintaining dignity, and he rarely shows emotion from the bench. Across from him that morning stood a very different figure, Congresswoman Jasmine Crockett, representing Texas's 30th Congressional District, a freshman in Congress but far from inexperienced. Before politics, she had built a formidable reputation as a civil rights attorney, fighting dozens of voting rights cases across the South. Born to working-class parents in St. Louis, her father a postal worker, her mother a nurse, Crockett knew what systemic barriers looked like up close. After earning scholarships to Rhodes College and the University of Houston Law Center, she dedicated her career to one principle: that access to the ballot box should never depend on your zip code or your skin color. What makes her so effective, noted UC Irvine professor Richard Hazen, is her blend of legal precision and personal empathy. She doesn't just know the law, she knows the people the law affects. The case that brought her before the Supreme Court that day was Henderson, County Election Commission v. United States, a case that could redefine how the nation understands voting rights. At its core, it was about a state law that had closed more than 200 polling places, most of them in minority neighborhoods, under the guise of optimizing electoral efficiency. The law never mentioned race, yet the outcome was impossible to ignore. Minority voters now had to travel 5 times farther than white voters to reach a polling place. Lower courts were divided. The Supreme Court had stepped in to settle the question once and for all. Was this simply an administrative reform, or was it modern discrimination disguised as bureaucracy? The morning of oral arguments, tension gripped the courtroom. Journalists, civil rights leaders, and state officials filled every seat. Crockett entered wearing a simple navy suit carrying a slim binder. No entourage, no stack of notes. Just focus. Chief Justice Roberts began the questioning. Congresswoman Crockett, your brief argues this polling formula violates Section 2 of the Voting Rights Act, despite containing no explicit racial classifications. How do you establish discriminatory intent when the text appears facially neutral? Crockett took a breath. Her voice was calm, steady. Mr. Chief Justice, the court's decision in Arlington Heights provides the framework for identifying discriminatory intent behind facially neutral laws. We must examine the historical background, the sequence of events, departures from normal procedure, and the law's practical impact. She spoke without glancing at her notes. In this case, all four factors point decisively toward discriminatory intent. The state's own pre-implementation analysis predicted these closures would affect minority voters at 3 times the rate of non-minority voters, and alternative plans that achieved the same efficiency goals with far less disparity were presented and rejected without explanation. Justice Alito leaned forward, skeptical. Congresswoman, correlation is not causation. Couldn't these disparities stem from population density or other neutral factors? Crockett didn't hesitate. Justice Alito, I agree. Correlation alone would be insufficient. That's why we've provided direct evidence beyond statistics. She lifted a single document from her binder. This memo, obtained during discovery, explicitly acknowledges that the formula would reduce turnout in areas that, quote, historically vote Democratic. Given the well-established correlation between race and partisan preference in this state, this statement provides compelling evidence of discriminatory intent. Justice Kagan entered the fray. The state argues that budget constraints justified these closures. How do you respond? Crockett's eyes flicked to her notes briefly. Justice Kagan, the record shows that the same state allocated $4.2 million to open new polling places in predominantly white rural areas, while claiming they couldn't afford to keep existing ones open in minority communities. That contradiction undermines their entire justification. Then came Justice Gorsuch, his tone sharp. The law itself mentions nothing about race. Are you asking us to look beyond the text? Doesn't that violate our textualist principles? Crockett didn't flinch. Textualism doesn't require blindness to context, she replied. This court in Arlington Heights made clear that facially neutral laws can still serve as pretexts for discrimination. The Constitution prohibits sophisticated as well as simple-minded forms of racial bias. The exchange drew a faint murmur from the gallery. Even those accustomed to the court's rhythm sensed something rare. The feeling that everyone, even the justices, was learning something new in real time. Justice Kavanaugh shifted the questioning. Let's assume a Section 2 violation is found. What's the remedy? Wouldn't we be dictating polling place locations from the bench? Crockett met his gaze. Not at all, Your Honor. The remedy simply requires the state to use a formula that doesn't impose disproportionate burdens. The state retains full discretion on how to do that. Courts have enforced similar remedies for decades. 40 minutes passed like 5. The questioning was relentless. But so was she. Each response was clear, grounded and sharp. No bluster, no hesitation, just law, evidence, and moral clarity. And then Chief Justice Roberts spoke again, his voice measured, but laced with something rarely heard from that bench: respect. Roberts leaned back slightly, his expression thoughtful. "Congresswoman," he said after a pause that seemed to stretch forever, "you've just cited precedent that goes back nearly half a century. And yet you've presented it in a way that makes it feel immediate, even necessary." That's rare. The room held its breath. You could sense every journalist waiting to scribble that line down. Roberts wasn't prone to compliments, especially not in open session. But something about this moment, the composure, the evidence, the conviction, demanded acknowledgement. Still, he wasn't done. "Tell me," he continued, "how do you reconcile this argument with our decision in Shelby County versus Holder? That case, as you know, limited the federal government's ability to impose pre-clearance on states. Are we not at risk of retracing those same steps? It was a trap, or at least it sounded like one. The Shelby County ruling had gutted the heart of the Voting Rights Act. Any attorney citing Section 2 had to walk a razor's edge between honoring precedent and exposing its flaws. Crockett didn't blink. "Mr. Chief?" "Justice," she began. Shelby County didn't eliminate the federal government's authority to protect against discrimination. It narrowed the scope of oversight. Yes, but it reaffirmed that the Constitution empowers this court to intervene when a state law results in racial disparities that cannot be justified by neutral principles. She took a small step forward, her voice unwavering. The court in Shelby County said our democracy depends on equal sovereignty among states. I would submit that it depends even more on equal access among citizens. That line, that one sentence, hit like a lightning strike. You could almost hear the click of cameras capturing Robert's reaction. He leaned back, pen in hand, but said nothing. Then came Justice Sotomayor, smiling faintly. "Congresswoman Crockett, you've given us a lot to think about. I'll just say this. Clarity is often the rarest thing in this courtroom." And with that, the arguments concluded. For a moment, no one moved. The courtroom, filled with decades of tension, precedent, and politics, felt transformed. When Crockett gathered her notes, she didn't look triumphant. She looked calm, composed, like someone who knew she had done her job, and done it well. Chief Justice Roberts rose. Thank you, Congresswoman. The court will take this matter under advisement. It was the standard closing phrase. But then he added quietly, and I thank you for reminding us what clarity looks like. That single line would be replayed on every news network for weeks. When the decision came down months later, it was narrow, 5-4, but historic. The court struck down the Henderson County law, holding that even facially neutral policies could violate the Voting Rights Act if they imposed unjustified burdens on minority voters. Roberts authored the majority opinion. In one of its most quoted passages, he wrote, "Our Constitution does not require blindness to the realities of discrimination simply because they come cloaked in neutrality. Justice requires not only what is written in the text, but what is written in the effect." Legal scholars would later call it the Crockett Doctrine, the idea that intent and impact must be weighed together when evaluating equality under the law. It didn't overturn Shelby County, but it reshaped how courts approached every voting rights case thereafter. In the weeks that followed, Congresswoman Crockett returned to her district in Dallas. There were no victory rallies, no elaborate press conferences, just quiet meetings with organizers, church groups, and students who had followed her arguments online. When a local journalist asked her what it felt like to be praised by the Chief Justice of the United States, she laughed softly. "Flattery doesn't change policy," she said. "Implementation does." But behind that modesty was a seismic shift. Across the country, state legislatures began reviewing their voting procedures. Civil rights attorneys filed new suits citing the Supreme Court's decision. And in classrooms from Yale to Howard, law professors dissected her arguments line by line. At Georgetown, Professor Sherilyn Ifill summed it up perfectly. What Jasmine Crockett did wasn't just win a case. She reframed how we talk about equality. She turned a technical legal argument into a moral one, and somehow she made both work. Meanwhile, Roberts's reputation also evolved. For years, critics had accused him of being overly cautious, obsessed with institutional neutrality. But this case revealed something deeper, a willingness to evolve, to adapt. During a rare interview months later, Roberts was asked why he had written the majority opinion himself. His answer was simple: because clarity deserves clarity. She gave us that. The exchange between the two, the Chief Justice and the Congresswoman, became a touchstone in American legal history. In law schools, it was studied as a model of persuasion, how precision and empathy can coexist in the same argument. In politics, it became something rarer. Proof that even the most divided institutions could still be moved by truth plainly spoken. And in the cultural memory of the nation, it became one of those moments people would look back on and say, that was when the noise stopped and reason finally spoke. Years later, when asked to reflect on that day, Jasmine Crockett offered a story. "My father used to tell me," she said, "you don't have to be the loudest voice in the room to be heard. You just have to be the one who makes sense." That's all I tried to do. She paused, smiling slightly. Turns out sometimes even the Chief Justice is listening. That hearing didn't just mark a legal turning point. It marked a cultural one. For a generation disillusioned with politics and law, it proved that integrity and intellect still had a place in public life. Clips from that day have been replayed millions of times online, not for outrage, not for spectacle, but for inspiration. The young woman standing calmly before the most powerful judges in the country, holding nothing but a binder and the truth. And maybe that's why the moment still resonates, because it reminded people that even in a system built on compromise, there are still flashes of clarity that pierce through, the kind that doesn't shout, the kind that doesn't trend for controversy, the kind that simply, quietly, changes everything. And as the camera panned across that marble chamber for the last time that day, Roberts seated, Crockett stepping back from the podium. There was no music, no applause, no theatrics, just a silent acknowledgement between two people who, for a brief moment, embodied the best of what the American legal system could be. Because justice, when done right, doesn't need spectacle. It just needs truth. And on that day, truth finally had the floor.